Now, to introduce ourselves, in case you do not know us, I am Annette Hines. I am the owner of Special Needs Law Group and Special Needs Companies, which really owns Special Needs Family Services, Inc. And I am the podcast host of Parenting Impossible, the Special Needs Survival Podcast. This is Mark Worthington. He is my partner in the law firm and also my husband. So we have a family business that basically runs all of those above. So together we are tonight going to present you with the new final rules and regulations. This is Bailey, the Wonder Dog. The final rules and regulations that have to do with ABLE accounts. So we did put out a Quickie podcast on this last week that came out on Friday. And Mark is going to be sharing his screen with our slides. And these will be available again on our website, specialneedscompanies.com. And also we are hopefully going to get this presentation out on YouTube. So we will again be protecting people's privacy. Please do feel free to post questions in the chat and also to put them in Q&A as well. I wanted to go ahead and add a poll question, and I want to ask you, how many of you have an ABLE account already? So I'm going to go ahead and do this. And I'm going to go ahead and post this question. Can you see that poll?
Where does it show up?
Let me see. As I'm learning how to use all these cute little tools. And I'm going to launch the poll. And I'm going to allow you to vote. Okay.
Oh, there it is.
There it is. So I'm going to give you like 20 seconds. Please let me know. I'm curious. Oh boy, look at that. All right, just going to give it like another 20 seconds or so. I put the not sure on there because some people, I think, might not be sure if somebody set up an ABLE account for their kid or their sibling or so forth. So if you're not sure if an ABLE account's been set up for somebody that you know. Oh, cool. That's split. Almost 50-50. I love it. Okay.
Awesome. All right.
Excellent.
So we should
Thank
get started.
you. All right. So let's get started.
I want you to.
I'm going to share the results. Here's the results of our poll.
Oh, cool. Wow. I'm surprised. All right, so I just wanted to say that this is our usual thing where we say that listening to this doesn't make us your attorneys and you can't hold us liable for anything wrong we tell you, et cetera, et cetera. So there, Annie, this is yours. I didn't show this to you, but this has to do with questions. I never even got a chance to edit this slide to tell them where to DM you. So it says XXX because I
oh, yes. Thank you. So I do want to bring this up. So this has been increasingly such a lovely issue that has come up because the podcast has gone international and Special Needs Companies and our Circle of Care through Facebook has hit humongous proportions. I am incredibly grateful for all of the support that we get. I get so many emails every day personally that it's becoming very difficult to answer them all individually, and I try. I really do. There are two issues with that. One, I can't give legal advice to people who are not my clients. So that is a problem from an ethical standpoint. And the second thing is that I am just overwhelmed with the number of people who want to connect with me. And so what I have started to do over the last couple of months, especially during the pandemic, is I have started batching the types of questions that I've been getting, and I've been answering them through social media, through Twitter, through the podcast, through blog posts, through LinkedIn, through just Facebook, everything. And I'm going to continue to do that. But I am probably not going to be able to answer direct questions by email, or if people are trying to reach me by phone. My deepest apologies. It's not that I don't want to talk to all of you, and it's not that I don't want to have a direct connection with all of you. I really do. I just can't keep up, and I am so grateful. Really, I am. So all of our contact information is on Special Needs Companies, and if you want to connect with us, please connect with us there. Thank you so much again for all of your support. So just go to specialneedscompanies.com and you will find all of the places to connect with us there. Thank you so much. Again, we are so grateful.
All right.
Okay, ABLE accounts are an amazing tool. They are not trusts, and I'm going to let Mark take it from here. What are ABLE accounts? Let's have a little refresher.
Please jump in whenever you want to fix what I'm saying. So we're going to talk a little bit about a refresher. Maybe half of the tonight's webinar will be a refresher about what ABLE accounts are. And I grant you, for some people, it may not be a refresher. It really may be new to you. How do they work and what good are they? Why should you care? And then the other half is going to be about the 2020 final regulations, which were just issued by the Internal Revenue Service earlier this month. If you don't know much about ABLE accounts, you may wonder what the heck the Internal Revenue Service has to do with disability issues. What's new, what's the same, what's a surprise, what's not. We'll talk a little bit, tiny brief history lesson, and then we'll hit 5 topics that came out of the final regulations that bear looking at. Who can establish an ABLE account and or manage an ABLE account. There's new news there. Issues about disability and eligibility, contributions, qualified disability expenses, and death and Medicaid payback. So, and in particular, I seek Annette's input on these, this first half of the presentation, which is what are ABLE accounts. We got federal legislation December 19th, 2014, and it added Internal Revenue Code Section 529 Cap A, which again, it's like, this is really a disability provision of the internal, excuse me, of the federal code. Why is what it did was it added a piece of the Internal Revenue Code. We'll look at that. The federal benefits program treatment of ABLE accounts having to do with countability and non-countability isn't in the statute. Sorry, I'm told I'm not being loud enough here. It's not in the statute. If you look in 529A, there's absolutely nothing there about how an ABLE account is treated for SSI purposes, Medicaid purposes, etc. You have to look in the actual act passed by Congress itself at Section 103. The first ABLE accounts didn't come until a year and a half later, June 2016 in Ohio. Most states have either an ABLE account now or they have an agreement with another state to piggyback on their ABLE accounts. Massachusetts, the ABLE accounts here are managed by Fidelity Investments, but you're free to go to other states. You can go to Ohio and have an ABLE account with them. They're called stable accounts there. You can go to most states. Very few states have restrictions on the residency of a person who has an ABLE account there. Last time I looked, Florida is one that had those restrictions. You have to be a Florida resident to have a Florida, to have an account with the Florida ABLE accounts. So, and that says that my voice is still no good. It's okay. All right, so the idea here was to kind of mimic, if you know about so-called D4A trusts, those are self-settled Medicaid payback trusts. And the idea with a D4A trust, which came about in 1993 by an act of Congress, you could, a disabled individual who was desirous of public benefits that are asset sensitive, typically an asset test of you can't have more than $2,000, for example, to qualify for SSI or some forms of Medicaid. You could take your excess assets, put them into this self-settled trust, meaning you are the beneficiary of the trust and you funded the trust. That's what we mean by self-settled. Normally that would be a countable asset. Magically, these D4A trusts were not. The key there was that they had a Medicaid payback. If there was still money in the trust when I died, if I was the disabled individual that funded it, Medicaid gets paid back after from anything left in the trust. If there's anything left over after that, then it can go to whoever my beneficiaries are and so forth. But that required lawyers, expensive lawyers. It required trust management and so forth like that. So somebody came up with the idea of these ABLE accounts. Why can't we just do this with an account? Great. And so ABLE accounts were born. But how is this going to be enforced? How can we have the Medicaid payback? How can we be sure this happens? So they got this idea. Why don't we have it enforced by institutions? Well, like a 529 college plan does. So they parked it right next door, created this thing called 529A, and said, great, we'll have the fidelities and so forth that we have, manage these 529 plans, and we'll have them manage these 529A plans. Great. And they've, Annette, do you remember there was some recent data about how much these plans are being used? Did you want to talk about that, or do you want to just move on? You're gonna, okay, and Annette will join us in just a minute. She's got to get her mic reconnected again. So what are some of the criteria? You have to have been disabled prior to age 26. That got in there because they were worried about busting the budget. It had to be budget neutral when they created these ABLE accounts, despite the fact that we're spending trillions of dollars. Now, how do you establish that? How do you establish your disability now and your disability prior to age 26? Proof from Social Security works, or there's a self-certification process. There's a lot of detail about that self-certification process that we're not going to go into tonight. Contributions to the plan cannot exceed $15,000 per year from all sources: grandparents, parents, friends, relatives, and the disabled person themselves, no more than $15,000 per year. Plus, and this is new from the 2017 Tax Act, if the disabled individual is working, they can add another $12,000, up to another $12,490 a year. That expires at the end of 2025, unless that provision is renewed. The maximum amount in the plan is your state's maximum 529 amount. The statute was written to have that be maximum contributions. That was too difficult to administer. By regulation, query whether they really have the authority to do this, but by regulation, the Internal Revenue Service says, you know what, never mind, we're just going to make it an account balance limitation, not a contribution limitation. Most states, that's somewhere up around $400,000 or $500,000. I forget the exact number from Massachusetts. But if you don't like the limit in Massachusetts and you find an ABLE account in another state with a higher limit, go for it. All funds are non-countable for Medicaid purposes. Only a $100,000, but only $100,000 is non-countable for SSI purposes. So if you pop over that limit, suddenly there's a disconnect in our SSI states, which I think is about 39 states or so, where SSI is automatic, regular, standard Medicaid. Now, if you have an ABLE account over $100,000, that is decoupled. The earnings are income tax deferred and maybe income tax free, depending upon whether or not they are distributed as qualified disability expenses. If the distributions are qualified disability expenses, they are income tax free, and they are not income for any federal public benefits purposes except for distributions, except that distributions for housing are what we call in-kind support and maintenance for Social Security purposes, SSI purposes. Did you want to say something about the?
I'm just trying to adjust your mic again.
Oh.
But you've got
What?
your settings different.
Okay, let me just, is this what you want?
No.
No, that's the speakers.
No, the Zoom. I was trying to do it without interrupting.
Okay, sorry.
Where's your settings?
I don't know.
Where's your Zoom settings?
Hold on, audience, I'm sorry.
There you go. Go and do it.
Okay. Sorry. Anyway, let me kind of go on to the next. I can't go on to the next one. Give me just a moment. Okay. Do you want to talk about ABLE accounts, how they've been, how accepted and how much in use they are right now? And then we'll go on to the next slide. And you're on mute.
Hi, everybody. Sorry about that. So many technical difficulties. I love the age of Zoom. So anyway, one of the blessings of these ABLE accounts has been that, you know, they don't require a lot of money to open them. So unlike, you know, kind of getting a trust started, which their complexity kind of behooves us to have quite a bit of money to get them going. Nobody wants to start a trust with just a few $1,000s, right? These accounts really, most places will open them with a few $100s, and depending on the institution that has set them up, they may have different minimums, but you know, we're talking about pretty small minimums. So the statistics for what's been opened since about 2015, we've got 71,000 ABLE accounts opened nationally and about $470 million in assets. And that works out to be about $6,000 per account on average, something like that. So that is, it's actually just under $7,000 per account, I think. So that's very interesting because it's actually much lower than they were expecting. When they started ABLE accounts, they thought that, oh my God, this is going to be huge. Everybody's going to jump on the bandwagon. People are going to love this. And it's not as widespread and as widely used as they thought. And, you know, one of the key factors in making sure that ABLE accounts are a huge success is to get volume in order to keep the financial institutions in the game, if you will, because of the cost of managing these accounts and reporting on these accounts. And so we haven't quite hit where we need to be with that. But it's still, I mean, 71,000 accounts in 5 years, considering how slow it took us to get the information out and to roll them out, seems like a lot to me. And $470 million in assets, just, it seems like a lot to me. So I don't know how you all feel about that, but I certainly felt like that was really great. So Paula said, She opened her account with $25 and funded it with a few thousand after that. Yeah, that's great. So Chip, thank you so much for your help with the with the volume settings. I really appreciate that. I think Mark's sound is better. I hope it sounds better. How many hours is considered working to be able to add the extra 12,490? There's no any work, any income from work. So any work at all.
It just needs to be income from work. There's a cap of that 12,000, whatever I said. That's keyed on the federal poverty rate. It's actually higher in Hawaii and Alaska. And the only thing, there's other restrictions too. If there were contributions to a 401k, 403b, et cetera, during the year, then you're not eligible for that. But yeah, there's always details that they have to throw in to make it more complicated.
What is the best way to take money out of an ABLE account to pay for an expensive item? You may go over 2,000 if you funnel it through a rep payee checking account. Let's talk strategies in a few minutes when we get to our questions, because that is going to be very interesting.
Yeah, don't forget.
Thank you.
That.
I'm going to hold on to that for a few minutes.
All right, so look, I jotted down a few uses. I mean, actually, we have pages of uses for these things, but just simple basic stuff like sweeping excess earnings or SSI from time to time. You get close to the $2,000 in a rep payee account or in some other accounts in total. Just sweep the excess in from time to time. Distributing cash from a third party or first party SNT to the ABLE account. Only cash can go in the ABLE account. And a contribution or money going into an ABLE account, Section 103 of the Act tells us that's not income to the individual, to the beneficiary. Then distribute from that ABLE account, and and then that avoids having income to the beneficiary for public benefits purposes, except, as I said before, a distribution for housing will be ISM, in-kind support and maintenance, for SSI purposes. That's the only exception for any federal benefits programs. You could also make distributions of cash out of the ABLE account, and it won't be deemed income for Section 8 housing, won't increase their rent for that month.
Right.
Save for expensive items like a car or a van. That relates to the question that we just had that we'll talk about. Okay, we saved, now we've got 20, 30, whatever $1,000 that we've been saving up for this van. How do we buy it without it being a problem? We'll get into that in a bit. So
right, let's go through the next just few slides that we have so that we can get to strategy and tactics.
That's all I've got on ABLE accounts as a kind of a refresher.
So let's talk about the changes, or
okay.
what's the final regulations.
So we'll get into the final regulations. Quickie history. So the ABLE accounts came out in December 19th, 2014. By June of 2015, we had proposed regulations from the IRS. Why the IRS? Because the Act said the IRS is going to make the regulations. Not long after that, there were some very serious comments so the way the regulation process works is they put out proposed regulations and then people get to comment. And based on those comments, the IRS immediately put out notice 2015-81 to address some of the more serious ones and said, okay, these aren't regulations. They're not even proposed regulations, but you can rely on them. They mean it when they say that. In 2019, we got proposed regulations, additional proposed regulations based on the 2017 Tax Act, for example, that added the excess contributions that can come in if you're working. And then finally, we just got the 2020 final regulations, which mostly incorporated the above, taking into account the over 200 comments from practitioners.
Mm-hmm.
And they did a good job. And mostly there weren't any changes from what we already had in the 2015 proposed regulations, notice 2015-81, and the 2019 proposed regulations. What we're going to talk about, therefore, is what did change and a few key things that didn't change that are still pretty important to talk about. I have 5 categories. The first one is authority. Who can establish and manage the ABLE account? They call it who's an authorized signer in terms of managing it. Well, what happened is this: the final regulations created a hierarchy of who can do this. We have the individual if they have capacity. And Annette wants to know, how do we know if they have capacity?
And I also want to tell you to stop moving around because you're making the microphone bad again.
Okay. Sorry. The agent under a durable power of attorney, if there is one. Next in hierarchy is the conservator or guardian, then spouse, parent, sibling, grandparent, and rep payee. There's a lot of issues that we can talk about here. Let me hit on a couple of them, and then I think Annette wants to talk about a few of them, or at least the last one. So, you know, it's interesting, in most states, or maybe a lot of states, a conservator can actually trump the power under state law of an agent under a power of attorney, and can even revoke it. But here, the agent under the power of attorney has first dibs. What about a spouse that you're not getting along with, maybe thinking about divorcing them or something? What if you've got 2 parents who are divorced and are at war? How does that work? Because as pointed out, I didn't put this in my restriction slide, you can only have 1 ABLE account, period, anywhere. Then we go down siblings, grandparents, and so forth. The way that the regulations decided that they would resolve this issue about who has capacity is, you know what, we don't want to deal with all this. Tell you what, the ABLE program, now a lot of these regulations don't say what you can do, they say what the ABLE program can do. The ABLE program could be the one in Ohio, the one in Massachusetts, whichever one you're dealing with, may, don't have to, may accept a certification from the individual on this hierarchy that says, yep, I'm authorized to establish the ABLE. No one with a higher priority is willing and able to do it, so I'm doing it. What if the conservator, what if the person signing the certification is, say, the sibling, and the conservator doesn't want an ABLE account? Well, they're not willing to do it, and so I don't know how that goes. Annette, you wanted to say a few things, I think, about this slide.
Well, I think it's interesting that it's saying that an individual can establish their own account if they have a court-appointed conservator. Because technically they really can't. Because they don't have control over their funds.
If they have capacity. Now, if they have a guardianship, maybe they don't, but a conservatorship does not require a finding of incapacity, at least not in Massachusetts.
That's true, but they wouldn't really have control over their funds. So anyway, it's kind of interesting, and I'm not sure how all of this is going to shake out. The one that really bothers me and some of my colleagues is the representative payee. And that is for us a new person in the mix of all of this. So generally speaking, a representative payee only has authority over funds that Social Security pays out. And Social Security gives them a report to fill out every year to explain how they've spent the money. And then purportedly Social Security has oversight and has authority over that representative payee. And there are consequences if there's fraud or misuse of funds in any way. A conservator, a guardian, a person under a power of attorney, they have oversight by the court, they have oversight under state law. Spouse owes a duty. Parents of minors owe a duty. Siblings and grandparents, no, not so much so, but at least most of the people on this list have some authority, legal authority, and there's some entity with oversight. But the representative payee normally doesn't have access to funds outside of the Social Security fund. And so my concern is now they may have access to these savings that a parent or a grandparent or some other person may have put in, or the individual may have put in here. And Social Security money may have gone in there or may not have gone in there, it doesn't matter, but there might be $50,000 in this ABLE account that came in from an inheritance or, some other savings or whatnot. And now this representative payee has access to it because they're on the list. And this is not just a person who can establish, but a person who can manage this account. And so I have concerns that we've now established somebody who could be an organization. I mean, we all know that representative payees are very often residential or other kinds of organizations that are not necessarily the best funds managers and who have a lot of transient people through them. I'm not sure that I necessarily want those people with access to more than a few dollars at a time with no real oversight and no reporting requirement. So that's been my concern since I saw this list.
And I'll play, I don't know if this is devil's advocate or not, I guess so, since we're talking about the IRS, but I think the idea was that, look, we're trying to make these things useful. We're trying to make it so that people don't have to incur all kinds of horrifying legal expenses or whatever to go to court and so on like that, to get appointed guardian and so forth. We just want people to be able to have these things. If everybody on the list before the rep payee is out of the picture, I mean, surely that's the thinking, right? Is like, well,
Right.
Geez, let's just fine. We'll let the rep payee do it. But another question I have is, well, okay, suppose the rep payee opens up an account and the rep payee is managing the account, and then sibling comes in and says to the, whoever the program is, Fidelity, or says, hey, I have higher priority. Get rid of the rep payee on this account. I'm taking over. What do? Do they get priority, or does Fidelity say, I'm sorry, rep payee got here first, signed the certificate?
Well, we don't know yet. So
No,
let's move on to the next slide.
Well, the next category is disability. A lot of little things. It clarifies that when it says eligible for SSI, it includes a person who's suspended due to excess income or assets. So it's really, I don't know, we just mean disabled enough. It had a glitch in the proposed regs, because where it said marked and severe functional limitations, it referred to a regulation from some other part of the federal code of regulations that said that means that they are unable to engage in substantial gainful activity. So
Very nice. Yeah.
Says, no, you can have marked and severe functional limitations and still be able to engage in substantial gainful activity. No change here in this. The final regulations continue to state that it is that the onset of disability has to have been prior to age 26, not the onset of the condition that eventually led to your disability. And the biggest thing I want to talk about here is that the regulations attempt to deal with the idea, or deal with the fact that in some cases, people can kind of ebb and flow.
Right.
And meet the definition of disability for some period of time, and then not meet the definition for some period of time, and then meet the definition again for some period of time, and so on. And so well, what do we do about this? Let's take care of it. And they said, well, during a period of non-eligibility because of the disability, non-disability meeting the requirements, the account, what if they already opened an ABLE account? So, all right, fine. The account is still going to be treated as an ABLE account for non-tax purposes and for all tax purposes, except that immediately, as soon as you are no longer meeting the definition of disabled, any expenses paid for you by the account or from the account immediately are not qualified disability expenses, meaning that there could be some tax consequences and so forth. But the problem I see here is that they envisioned that you could potentially not meet the definition of disability for ABLE account purposes and yet still be eligible for certain means tested public benefits. And so they didn't want the ABLE account distributions to disqualify you or negatively impact those public benefits. And yet they say, well, they're not qualified disability expenses, but in order to have no effect on public benefits, they have to be qualified disability expenses. So I'm not sure, I have to look further into this, but it's possible that they made a little oopsie in the regulations. And then
So that's a little confusing.
A bit, we'll see. And then contributions beginning the next year are not allowed. So if you August 1st, now you don't meet the definition of disability anymore, contributions can still be made in that year.
I think really what the takeaway is, just because that was very confusing, not confusing the way Mark said it, but confusing the way they have explained it in the regulations, is if you just boil this down to the basics, if you are no longer disabled for public benefits purposes and you can still have an ABLE account and you take out a distribution from this ABLE account, you are potentially going to have some tax implications, and you cannot contribute in the following year. So those are really the two takeaways from this, that you just need to boil that down to the simple, thought process around that. But that doesn't mean that you have to cash out the account, because they do recognize that you may need it again. Just like Social Security also gives you a lot of chances to go back on benefits, ABLE account kind of follows in that same vein and gives you a lot of chances to maintain that account in case you still need it. So if you don't take any money out of the account, and if you don't continue to contribute to it, the account can sit there in case you need it, and it can continue to grow tax-free. Okay, so it's just really, don't take any money out, let it sit there. And if you end up going back on benefits, you end up meeting the definition of disability again, then you are okay. If you really end up being not qualified as disabled and you take money out, they are not going to be considered qualified disability expenses, and you are going to have some tax implications, period. Okay, next slide.
Regarding contributions, the regulations clarified, they didn't make this something new, but those excess contributions that you can make over the $15,000 if you're working, up to $12,000 something or other, clarified that has to come from the disabled person. It can't come from the outside. So if you're working, you can't have outsiders contribute that $12,000. That has to come from you. We're down to my last two categories here. Qualified disability expenses. We still have the same very, very broad definition that the Internal Revenue Service gave us in the proposed regulations from 2015. Annette, did you want to speak to that just a minute? Because I know that's—
I do. So here's the issue around these qualified disability expenses. This is a very broad definition. It remains very broad, but it doesn't include everything. And I have had many, many people, even professionals, come to me and basically say, well, I have been told, or I read that. And essentially they want to tell me that, they can basically take a trip around the world and, or they can, really, anything goes. This is not really true. These disability expenses have to be tied to disability, and they have to be tied to, basic living expenses in some way, one or the other, really. And so you're not going to take that trip around the world, or that, that luxury. You're not going to buy a luxury yacht. I mean, not that $100,000 can do that, but you're really going to be thoughtful about what you're spending the money on. If it is purely recreational, and I always use the example of, a diamond ring, there is no therapeutic, disability, basic living, redeeming kind of quality to that expenditure. And I think you're going to have a hard time getting that through as a qualified disability expense. So that is really something that you do need to consider. So it's not really anything goes. Most
All right.
things do. Okay, we're running out of time, and I want to make sure we
So
get
the
to questions.
I just want to say really quick, the next 3 bullets here are just all about how all of the worries about that the program is going to, the ABLE program is going to have to, report and distinguish about qualified disability expenses versus non, or
Right.
versus, forget all that stuff. All that, they realize that that's just not practical. Main thing here I want to point out is kind of an interesting little thing that we didn't expect. The regulations say that a beneficiary can treat qualified disability expenses made by the 60th day following the end of the beneficiary's tax year. So for most people, that's going to be maybe around March 1st or so, as being made in the immediately preceding tax year. So if it's helpful in terms of adjusting, tax issues or something like that, you can do that. I haven't thought through how that can be beneficial, but I'm sure it is. Also, one of the things is that on December 31st, we typically do not know how much taxable income do we have, how much income did the ABLE account make. We don't know that on December 31st. Finally, we have death and Medicaid. Hey.
Yes, because we do have a question about funerals. So let's finish this up so I can get to questions.
This is some of the most interesting stuff in the entire final regulations. Now it says that, again, this is the ABLE program may, not that you may, if the ABLE program doesn't like it, but if the ABLE program may permit the beneficiary to name a successor eligible beneficiary that would take effect at that first beneficiary's death. We didn't have that before. It would just go to the probate estate. So that's really cool. You can name a successor. Medicaid still has to get paid back, but if there's anything left, it can go to that named successor. The payback, remember, don't forget, is, excuse me, the Medicaid payback, just remember, is only for medical assistance. That's MA, not Massachusetts. It paid after the establishment of the ABLE account. That's a big difference from D4A Trust, which is payback from the beginning of time. That's not new in these regulations. Just wanted to point that out. Regulations state that it is okay for the state to require the state Medicaid agency to not file a claim for payback. California has done that. And finally, and this is really huge, it is okay for the ABLE account to pay for qualified disability expenses, even if not for a pre-death contract. So the person can die, the ABLE account can pay for a funeral. This is unlike the D4A Trust, which follows what is called the Social Security stinking dead body rule. Annette?
So I'm going to jump to questions because I do have kind of a hard stop in a few minutes. What is the best way to take money out of an ABLE account to pay for an expensive item? Great question. You may go over $2,000 if you funnel it through a rep payee checking account. The best way to do this is to actually pay for the item directly. However, that's really challenging because Fidelity doesn't let you write a check directly from the ABLE account. You have to open up this companion account and funnel money over to the companion account. But if the money goes out right away, goes into the companion account and then goes out right away through a check or through a, some kind of a debit card purchase, then it doesn't spend any time at all. And with Social Security, they're not looking at, oh, you went over $2,000 for 30 seconds. They're looking at what happened within a month period. So
That's
you're
right.
usually okay within that 30 days. So you have time to figure that out. Also, you can reimburse somebody who has put something on their own credit card, and then you can pay them back. So if somebody else puts something on their credit card, you are able to pay them back for any purchase that they do. Next question. Does that mean I can deposit 27,000 per year and not 15,000? What about a deposit on a condo? So yes, you can deposit 27,000 if some of that is for work income. So if somebody actually earns income from work that brings that level up to the 27,000, yes, you can, as long as that extra 12,000 is for work. Yes, you can put a deposit on a condo because that is for living expenses. Okay, the money left over upon death has to go back to Medicare. No, people make that mistake all the time. There's a big difference between Medicare and Medicaid. It's Medicaid, or our state Medicaid program, which is called Mass Health, that has the remainder interest, or the payback provisions, not Medicare. So people do confuse that all the time. And yes, there is what we call estate recovery or payback provisions in these accounts. So we don't usually like to see them build up too much, but it is an account that will have payback provisions. Okay, big issue with COVID and pandemic unemployment assistance for Massachusetts. Our son was laid off and he earned at a job $900 from January to March, and it was way more than he normally made. So 13,000 approximately of deposits. Then he had savings bonds. He can deposit this money from his earnings. How does ABLE see the PUA money, which is technically a form of unemployment, not employment? The PUA keeps coming, and if we can use this as part of the 12,000 will be a huge help. I am guessing this is an issue nobody envisioned happening. I do not think that that is income from work, and I don't think that that is going to qualify. I am not sure 100%, but I mean, just like every other Social Security regulation, Social Security only counts actual income from work from hours worked. They don't count hours paid for, for time off, paid time off. They don't count sick time paid. They only count actual work hours. So my guess is this unemployment pay is not going to count as well, just because the ABLE accounts come from, sort of that same body of, even though it is IRS regulations, they do lean heavily on Social Security rules as well. So again, I don't think this was something contemplated. My guess is you might want to look at a D4A trust to keep him under, or to look for something that you can spend it on to spend down. Group home and DHAB loses my son's clothing frequently. Is clothing, clothing is definitely a qualified disability expense. Absolutely. Can a housing purchase be in the ABLE account recipient's name and co-owned by the parent? No. You have to spend money on something for the recipient. Although actually, I mean, why not? I mean, certainly their share of whatever purchase.
If there was pro rata contributions in the purchase.
Right, as long as they weren't paying into something that they didn't have an ownership interest in. However, I would be very careful about how something was structured.
Yeah.
That I think that would require some very serious thought before you jumped into something like that. There are so many different ABLE accounts, consortiums in different states. What's the best way to go? Who do we go with? So if you look at the ABLE consortium and you look at all the different states that have them, you can compare and contrast what the different states have. That would be helpful in figuring out what the minimums are, what the fees are in each state, and how each state manages their account, because it's the different institutions. The federal rules don't change, but for example, Fidelity doesn't have an account that you can write checks or have a debit card. Other states might have, better flexibility. So those are the kinds of things that you want to look at.
I think a pretty good resource is a site that's ABLE RNC. Excuse me, ABLE NRC, National Resource Center, ablenrc.org. There's a lot of good information there.
Okay, would saving for college education expenses be allowed with ABLE? Absolutely. That is absolutely an expense that you can save for and spend on. And can money go right from savings bonds to an ABLE account without messing up SSI? Okay, that is a very loaded question. And because you have the savings bonds, if they're over $2,000, you're going to already have a problem with SSI. You can take that money if it's under 15,000 and deposit it into an ABLE account. And after it's in the ABLE account, then you won't have a further problem with SSI. But if it's over $2,000, you've already got an SSI problem.
And remember, you can only put cash in the ABLE account. So you would have to cash out.
Cash them out. So you've already got an ABLE account. You've already got an SSI problem if you have any assets over $2,000. So with that, I am over my time. I've got to run doing a fantastic podcast with somebody from Canada who I am now late for. So I have got to go. But we loved this. Sorry for the technical difficulties. Thank you so much for bearing with us. Our computers are so tired from all of this zooming we are doing. And we will post this to YouTube and to our special needs company's website. Please keep connecting with us and keep the questions coming in. I promise we will answer them, just not directly in our email. And we will definitely get back to you. And I will try to do another podcast with a, questions like I usually do. Thank you so much. Talk to everybody soon. Bye now.